The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honor.
Please be seated. Good morning. Welcome to the Fourth Circuit Court of Appeals. Let me just start by taking a point of personal privilege to say this is an unusual situation for me to be sitting in the middle, and to my left, Judge Motz, who's taking senior status. I'll say that, Judge Motz, because if it finds during the proceeding I hesitate for Judge Motz to act, it's because I've been doing it for the last 12 years, and now it's a new thing for me. So with that, we will begin our proceeding today and start with the first case on the calendar, Alvarado versus Garland. And we will hear from the appellant.
Good morning, Your Honors. May it please the court. My name is Daniel Tolman, and I represent the petitioner, Manuel Orellana Alvarado, in today's case. Mr. Orellana Alvarado raises essentially three primary issues for this court to consider. The first is whether the board's decisions in this case, there were two decisions, are void ab initio because each of them involved at least one temporary board member who was serving at the time beyond their authorized 6-month term, which is a violation of 8 CFR 1003.1A4. The second argument relates to the merits of the actual decisions. The board in this case, in its first decision, sustained an appeal by the government following the immigration judge's grant of his application for withholding of removal. And we feel that that decision itself was incorrect, as well as the second Board of Appeals decision, which affirmed the first one. So we take issue with the merits of both of those for different reasons. And finally, we believe that the board incorrectly denied the petitioner's application for relief under the Torture Convention in the second appeal, which followed the remand from the first time around. So I'd like to begin of course, Sharon.
Over here, sorry. Can I add a fourth question to that, which is the government's recent 28J letter about jurisdiction? You haven't had an opportunity to respond to that, and it seems like a thorny question that we may have to resolve before we resolve any of these other questions. I wanted to give you a chance to mention it.
Thank you, Your Honor. I appreciate that. As Your Honor points out, the 28J letter was received 2 days ago. So no, I have not had an opportunity. Obviously, we are amenable to supplemental briefing should the court desire it. But I will say regarding that issue, just a few things, that it has been the longstanding precedent in this court and other courts that this is the way that you challenge reinstatement. You have to go through this process. This court in just
I'm sorry, I can't hear or understand.
I apologize, Your Honor. I'm not close enough to the microphone.
Well, I couldn't understand it. I could vaguely hear it, but I couldn't understand it. So
I apologize, Your Honor.
No, it's
I've
all right.
adjusted the microphone, so hopefully that helps.
Perfect.
So no, we haven't had a chance to respond. We're amenable to supplemental briefing. It has been the longstanding precedent of this and other circuits that this is the procedure by which you challenge a reinstated order. For example, in Mejia versus Sessions, 866 F3rd 573, this court in 2013 entertained an appeal that was filed in the exact same way, similar posture of case. And just recently, and following Patel in 2022, Tomas Ramos versus Garland, 24 F4th 973. It's the same thing. This is the way it's always been done.
But the concern, right, is that the Supreme Court in Nasrallah said maybe what we're doing is not right, and it's jurisdictional, so we have to address it whenever it comes up.
And again, Your Honor,
we can't assume that in cases where we haven't addressed it, we can't assume that it was actually considered, right?
Correct, Your Honor. And in a case, unfortunately, right now, the citation escapes me because it was my own case. And around 2015 or 16, the Seventh Circuit actually granted the government's motion to dismiss a petition for review that I filed following 30 days following the actual final administrative order. And the basis for the denial was that we were still holding only proceedings and we had to wait until it went to the board.
Sure.
So, but I understand your Honor's point. And actually the arguments raised in Patel were exactly my arguments at that time. But well, again, adding the supplemental briefing, yeah, but
might be helpful here.
but additionally, Your Honor, just it represents a very strong departure, a very like 180-degree turn from what's always been done in every circuit. And the presumption of reviewability would be eviscerated if the court adopts the Patel reasoning. And the reason for that is that realistically, the timing of these decisions, the way that petitioners are informed of an outcome of a negative finding or the issuance of a removal order often extends beyond the 30 days. So by the time they even find out that they're actually going to be removed, they have no time to appeal. The date of issuance of the order controls. And additionally, nothing in the record in this case, I did check this over last night, nothing in the record in this case shows that any of the decisions that were handed to them, the notice of reinstatement, the finality of the reinstatement, none of those advise them of the need to file a petition for review within 30 days. So if petitioners are issued these notices, they are not told that they need to file within 30 days or else they waive their right to appeal. So essentially adopting the Patel reasoning would eviscerate the presumption of reviewability. But again, supplemental briefing would be, if the court wishes, would be a better way to address this. If I may move on to the first argument, which again is, well, essentially the concept that these decisions, the first one by a 3-judge panel that was issued March 29, 2021. The panel included one board member, Pepper, who at the time was a temporary board member that was serving beyond her appointment of 6 months. The second decision was December 21st, 2021. That was a sole panel consisting of Judge Liebman.
Is your point here that when you look at the A4 and you look at 10E, because that word renewable is there, that first one that you are dealing with only deals with just one time you could be 6 months?
Yes, Your Honor.
But now, you know, that was done back in 1998, that first one. Then they come back in 2014 and then enact this one renewable. So how does that work? I mean, you know what the practice has been. It's just like what you said on the jurisdictional thing. I mean, you know what's been going on. And now you're saying you're sticking the word renewable, and somehow something you've been doing all the while now has been informed by the subsequent action. How is that possible?
Well, Your Honor, there's a couple of reasons.
Maybe, but how strong are
yes,
how much time do you really want to spend on it?
Well, the first thing that I'd like to say in response is that when they added renewable, it's important to keep in mind when they do these regulations, they generally track each other. They're very similar language when it comes to immigration judges and board members.
Understood, but you know how these things are working. They are trying to get some help on these boards that have been doing this. Put someone up there 6 months, and then that's it. You got to go find someone. I guess you say you can't even use those people again.
Well,
maybe not in line or whatever. But anyway, well, go ahead if you want to go in this direction. I'm just saying that looks pretty compelling to me. I mean, if you'd had that first one there, and then the second one comes up, I got it. But this thing had been around for 16 years, and all of a sudden, then they do this and put renewable, and you now say, well, you can't do it.
Well, Your Honor.
And is anybody else held that?
Your Honor, this issue has come up in some other circuits.
Has anybody else held it? Has anybody agreed with you?
Not yet, but it has not been argued in this way yet, as far as I'm aware, at least in the decision. And Irineo Cuenca Brito versus Garland in the Seventh Circuit, I actually had that case as well. The court declined to consider this issue. However, I did not raise the issue of the non-renewability at the time. It's a new issue that has come up, and I've since learned from colleagues a bunch of different approaches that they've been using in their cases. So that's a key difference.
It's pretty well understood in terms of where you're going. We're either going to do that or not. I mean,
well,
that's kind of where.
So Your Honor, if I may, to go back to what you're asking about, to me, the more compelling thing is that in 2014, they added renewable to the temporary immigration judge provision, but not the board member. It's right there. They know what they're doing. They could have done that if that was their intention. And Your Honor, since you mentioned 16 years have passed prior to that, 10 years prior to that, the rule said for whatever term necessary. So that 16-year mark that Your Honor references actually included a limitation saying, you know what, whatever term necessary, we don't need that. It's going to be 6 months. And then they go back 16 years later and say, you know what, we're going to let these guys renew, but not them. To me, that's the compelling and proper way to interpret the regulatory history. And Your Honor, if it was an oversight on their part, the record could reflect that, and they could have easily amended it at any point between then and now. This is an issue that just started coming up recently with the.
Speaking of how recently this came up, did you raise this in front of the board?
No, we did not, as a matter of fact. And there's a few reasons for that, which I think we discussed them a little bit in our
Does that
reply.
prevent us from considering it?
No, Your Honor, it does not. However, I would like to point the court's attention to Santos Zachariah versus Garland, which is pending at the United States Supreme Court, addressing the very issue of whether a motion to reconsider is required. The docket number.
That's not really the question here,
Oh,
isn't it? The
sorry.
question here is we addressed in Cabrera in our decision, right? That you have to raise an issue in front of the board at least once to have exhausted it. You don't have to file a motion to reconsider in every case. The board doesn't have to reconsider something that's already been presented to it. But we said you have to raise it at least once in front of the board, whether that's before they rule or after they rule. At some time, they have to be apprised of it before you can bring it here because of the exhaustion requirement.
Thank you, Your Honor. And the problem in this particular situation, and specifically, or more clearly with the second decision, the December 21st, 2021, that was a one-judge panel. That's who the reconsideration gets reassigned to. So if that person is serving without authority, then what is the point of asking that same person to reconsider whether they should have stepped down, whether they should have heard the case in the first place? It would be a futile motion. So
But they would reassign it if they agreed with you. I mean, are we allowed to make exceptions to this statutory exhaustion requirement?
I believe so, because the due process issues involved were denied in this case. I mean, due process was denied. The decision was handed down by somebody who did not have the authority to hand it down. And the agency is just completely sidestepping the due process requirement that a duly appointed board member be the one that adjudicates their case.
Maybe if you had mentioned that to the board, they would have agreed with you and put someone else on the case or changed the way they do these appointments.
The way that the cases are assigned, as I understand it, essentially it does not go to a full panel to then decide who's going to do this. It would go back to the same board member that issued the decision, and they would be the ones that would have to perceive a conflict. And honestly, if that board member were to perceive a conflict, they would have stepped down before issuing the decision in the first place. So I think in this case, reconsideration would have been futile. And as far as the other appeal, at the time, we filed our first petition for review for following the first decision. That was one judge out of three. It was the government that appealed the decision that time, and that appeal was sustained. I'm sorry, the government appealed the judge's decision, and then that was sustained and handed back down. In the appeal of that, there really wasn't an appeal of that on our side. We filed a petition for review. That was the first shot that we could get at doing that, because the case had been remanded for consideration of additional non-discretionary relief under the Convention Against Torture. So at that point, there was no way to raise it to the board. The petitioner, who again has been detained for over 4 years, I guess they could have delayed their proceedings even longer by going back to the board to challenge the involvement of Judge Pepper in the first decision. But they had their remand. They'd been granted withholding of removal. And it was just to consider whether they be granted relief under the Convention Against Torture. And then that's how we get into the merits issues
Well,
of how the,
counsel,
yes, Your Honor.
speaking of the merits issues, you've spent all except 1 minute of your time not on the merits issues.
Yes, Your
And the
Honor.
very best you get out of all of these other issues is to go start again on the merits, right?
Basically,
So that if your client has been detained for all this time, I would think that you would be jumping right into those merits issues.
and Your Honor, that's a good point, and I'd like to use my remaining 45 seconds on the merits, if that's okay. The
5 minutes in rebuttal. If you want to use that, you do that.
I can add my rebuttal time. May I transfer 3 minutes from the rebuttal?
Yes.
Yes.
Thank you. I appreciate that, Your Honor. Thank you for the heads up.
Just remember when you come to rebuttal.
Yes, of course. So in terms of the merits, and first of all, Your Honor, regarding what happens next, the relief at issue is non-discretionary. So if this court finds that the board reached incorrect decisions regarding the merits of the case, it can simply reverse the orders. And that, keep in mind that the initial judge, the immigration judge in the case, the one who heard all the testimony, granted withholding of removal. And so essentially we'd be going back to that decision. This court can find that everything since then has been flawed and that judge's decision for non-discretionary relief should stand. So this court can actually grant the petitioner the relief that he sought in the first instance, withholding of removal under 8 U.S.C. 1231b3, and we'd be done. That would resolve everything. The court, of course, can remand the case for additional proceedings or reconsideration or a new decision by different board members, but it also does have the option to grant the relief. And the reason the relief should be granted primarily turns on the factual misunderstanding by the board regarding one incident in particular. The petitioner had been a taxi driver who was forced by the MS-13 to perform work for them. And he did not want to do that anymore. He told them, I don't want to do this anymore. And he saw them interacting with the police and handing them drugs and hanging out with them, uniformed officers. He didn't want to be a part of it. So he informed them of that and they told him, well, you stop driving, we'll kill you. And then one day he stopped driving. They came and checked on him after a couple of days. What's going on? Why aren't you driving? He resumed driving. Then he stops again. And the same thing happens. Then finally, after a relative is murdered, he decides he needs to flee the country. So he flees the country, comes to the US, he is detained, he is removed. 3 years after he left in the first place, he is spotted by members of the MS-13 that he recognized from the old neighborhood. They recognize him. They approach him. They tell him, you shouldn't be here. We're going to disappear you or kill you. And then this is where the key thing happens. There's apparently some sort of meeting going on. He sees people going up the hill, other MS-13 members. He thinks there's a meeting or something. And he says very clearly in his testimony and in his declaration that he thought that was the only reason, that the meeting was the only reason he was able to flee with his life. The only reason they did not kill him that day. And however, on appeal, the board took those same facts and somehow inexplicably felt that the meeting was the only reason they told him he couldn't be there, which is the opposite. He was recognized 3 years later. What's to stop them from recognizing him 3 years after that happened now if he is sent back? So his life is in danger. The judge's initial determination was correct, and this court should overturn the board's decisions in this case. Thank you so much. I appreciate the extension of time.
Thank you. Thank you for respecting the time.
Bless you.
We will now hear from Ms. Stokes remotely.
Good morning, Your Honors. May it please the court. My name is Jessica Strokis, and I represent the United States Attorney General. First, I'd like to thank Petitioner's Counsel and the court for their flexibility and understanding due to my unforeseen illness this week. Thank you for allowing me to appear virtually. The court should dismiss or deny the petition for review in this case. First, with respect to the 28J letter filed this week regarding Nasrallah, the government's position, I acknowledge, has changed due to the Supreme Court's instruction in Nasrallah regarding what is a final order of removal and what is not a final order of removal, which would include withholding only proceedings. I do agree that this court could likely benefit of supplemental briefing on that issue to address its jurisdiction. Obviously, this court has jurisdiction to determine its own jurisdiction, and should the court determine that it need to address, should it determine that it needs to address its jurisdiction in this case, and whether it has jurisdiction, given that this is it stems from a reinstatement order and withholding only proceedings. Certainly, I do think that this court could benefit of supplemental briefing. However, the government also understands that given the late hour that this issue has been raised, and that this does represent a change in the government's position, that alternative to outright dismissal, this court should deny the petition for review, and clarify simply that for future cases that withholding only denials should only be reviewed if the petition for review is filed within 30 days of the reinstatement order.
Can we actually do that? I know there are courts that say we can assume statutory jurisdiction, but it seems like the Supreme Court has spoken loud and clear in Steel Company that we cannot assume jurisdiction, whether Article 3 or statutory, that if we don't have jurisdiction, we can proceed no further.
Yes, Your Honor.
I'm not sure we can just assume it and deny on the merits, as you suggest.
I understand the concern there, Your Honor. Yes. Yes, simply because this was a kind of a late in the game position change on behalf of the government. Certainly, we don't want to come across as being unfair to petitioner's counsel or to the petitioner in this case. I believe that the first petition for review in this case was taken in, was it 2018 or 2019 before Nasrallah? Certainly jurisdiction. It's a tricky issue. It's a complicated issue. So if this court does feel it needs to address its jurisdiction, given Nasrallah and what does and does not constitute a final order of removal for purposes of jurisdiction, I would ask the court to allow for supplemental briefing on that issue.
Does this question in terms of jurisdiction basically represent, maybe from petitioner's perspective, a sea change in the law? In other words, is a major change from the way we've done things and other circuits have done it?
Your Honor, I believe it would. The government's position in the past has been that the petition for review can be taken from the board's decision, even following reinstatement orders. Nasrallah changed that, and Nasrallah,
because if we go this way saying the Supreme Court is telling us to do it, it doesn't appear to be that direct of a determination by the Supreme Court with a consideration of what it is. And, if the Supreme Court wants us to do that, it certainly can have an opportunity. But the whole business of whether we can assume, particularly when we're dealing with a matter that potentially if we chose to deny it, I don't know what that means or how that's going to impact on it. But to make a sea change in the law like this of a circuit based upon the way we read a Supreme Court case that potentially holds this, it just seems like it would be kind of drastic at this point. And as you said, even you put in this letter and it's like last minute. Now it sort of changes the way we do all business that we're doing. We're going to write an opinion based upon this 28J letter sent to us right here now. And even if we get supplemental briefing, I don't know what we get on it. The results of it are just enormous. And I'm not sure that was even or has been considered. Maybe the Supreme Court wants it to be that way. I don't know. But for us to do it seems kind of drastic.
Yes, Your Honor. I understand the concerns, and certainly this is a change, and it's simply based on the reading of Nasrallah. I will note that two other courts have held that I believe it was the Second Circuit and the Fifth Circuit have since held that a petition for review must be taken within 30 days of the reinstatement order because of the way the Supreme Court explained what constitutes a final order of removal and what is not included in that. So it's strictly a reading of the statutory text and the Supreme Court's kind of drawing of lines between what a final order of removal is and what withholding only proceedings are, which are not part of the final order of removal. However, again, it is a sea change. It is a change in how things would be done, and therefore, I do think that supplemental briefing could assist this court greatly. Regarding the second issue that petitioners raised, first, I would state that the government agrees that this court does not have jurisdiction to consider the board members' authority to issue orders in this case. First, because petitioner did not exhaust the challenge before the board. I believe it was Cabrera where this court said that the petitioner must first raise an issue to the board in the first instance, whether it be in a direct appeal or in a motion to reopen or reconsider, so that the court may consider the issue on petition for review. That issue is before the Supreme Court at this time, but even if this court could consider the issue, even if it was exhausted or exhaustion was not required, the petitioner lacks standing in this case to challenge the temporary board member's appointment, because the regulation that allows for their appointment concerns the board's organization, management, and internal procedures and does not create any enforceable rights. The respondent's brief pretty thoroughly addresses the lack of standing in this case to challenge, excuse me, the appointment of the temporary board members. And essentially, the relevant regulation was authorized in part by 5 USC section 301 and promulgated without notice and comment because it relates to the agency's organization and management. And the Supreme Court in Chrysler Corp said that statutory section is simply a housekeeping statute that does not authorize substantive rulemaking. And to have effective law, a regulation must be a substantive or legislative type rule, be promulgated in accordance with rulemaking provisions of the APA, and a nexus must exist between the regulation and some delegation of legislative authority by Congress. That simply does not exist here, and therefore the petitioner lacks standing to challenge the board member's temporary appointment. Even if he did have standing, however, he still has not presented a reviewable prejudicial challenge for similar reasons that this court has pointed out already in questioning on the direct presentation. Turning instead to the merits of this case, substantial evidence supports the agency's denial of withholding of removal for two reasons. First, the record does not compel the conclusion that a group consisting of Honduran males who reported cartel activity to the police. I'm sorry, that's a different case. The other case I was intended to do today. Excuse me. It was former taxi and/or transit drivers or business owners.
All right, I want to tell you that's okay. Judges do that from time to time.
It was former taxi and/or transit drivers or business owners who cooperated with MS-13 and then stopped. A key portion of this particular social group that was proposed is the term former. Social distinction, as this court is aware, is a fact-based inquiry, and it asks whether the group members are perceived as a group by the society as a whole, or by the society at large, to that at least one of their shared traits makes the group
Let me ask you
set
a
apart from the rest of society.
question regarding in terms of that nexus and this particular social group. The former seems to be what the board turned upon very sharply. He did receive a death threat very quickly after returning to Honduras in 2017. And at least that seems to be what the record is showing. And he was threatened by these MS-13 members from his old neighborhood who recognized him. So why is that not reasonable to suppose that those threats are actually related to his status as a former taxi driver who had ceased operating?
Your Honor, it would be speculative. In the petitioner's description, in his testimony of the event, he states that he was approaching, he was about 2 blocks away from where his son was. He was visiting his son. He started to see gang members kind of descending on one area, gang members people that he knew to be part of the MS-13 gang. He saw gang members starting to patrol the area. So he kind of believed that this gang meeting was about to take place. When 2 gang members approach him and tell him, you need to leave, you need to disappear yourself, or we're going to kill you. Gang members don't say anything about him being a former taxi driver. There's no mention anywhere in the record linking his status as a former taxi driver to this threat that happened in 2017. And importantly, in Toledo Vasquez, this court said that the timing of threats can be relevant in determining the persecutor's motivation. The timing of the threat in this case was pretty linked to a bunch of gang members coming into the area, presumably for a meeting, and other gang members patrolling the area. There's not a nexus to his status as a former taxi driver. It really, his testimony reads as, I was in the wrong place at the wrong time, because the gang members were in this area and trying to meet, and there were patrollers. If it could have been anyone, if the patrollers could have approached and said, you need to leave or we'll kill you. That they didn't want anyone in that area at that time. Certainly unfortunate, certainly not something that anyone should condone. But it doesn't show a nexus to a group of former taxi or transit drivers. Again, I emphasize that it's important that the petitioner included the term former in his group. The board has said that it is the petitioner's burden to clearly indicate the exact delineation of any particular social group that he wishes for the agency to consider. And so if he wanted to include current drivers, if he didn't want to, it be limited to former drivers, he could have made that delineation, and he did not. And also to where the petitioner tries to step away from the use of the term former, ignoring or removing former from the group would necessarily remove immutability. And the petitioner acknowledged that in his briefing before the board on page 88 of the record. And that goes back to matter of Acosta. When the board first started addressing the term particular social group, I believe matter of Acosta was about current taxi drivers, was essentially the group in that case. And so formers is a very important part of his particular social group.
Counsel, are you familiar with our decision last year in Nolasco? That was a similar situation where I think the group was former gang members, and the board said that social distinction hadn't been shown because the evidence that was presented didn't distinguish between former and current gang members and how they're perceived by society. And we affirmed that decision, or we denied the petition because of that distinction between former and current. And that seems pretty on point here, I would think.
Yes, Your Honor. The government would agree with that statement, that Nolasco v. Garland would support the government's position in this case, although gang members and taxi drivers obviously are different groups. The inclusion of the term former in Alaska was also of the term former in the particular social group seen in Alaska was also very important to the resolution of the case. And
both
similarly in this case,
former is what makes it, seems the parties agree, former is what makes it immutable, right? You have to have immutability. So former is added to these PSGs to make them immutable. But then you have the added burden of showing that the former members of this group are perceived as distinct by society in a way that's different from the current members of the group, whether it's gang members or taxi drivers or what have you.
correct, Your Honor. And in this case, the evidence simply did not demonstrate that specifically former drivers, as opposed to those who continued driving, were recognized by Honduran society as this distinct group. It did not show that the gangs or anyone else in Honduran society or Honduran society as a whole took notice of former taxi drivers as opposed to current drivers. I'd like to quickly pivot to the denial of cat protection. First, the record does not compel the conclusion that that the petitioner established it was more likely than not that he would be tortured in the future if he was returned to Honduras. There is no evidence in the record that the gang has continued to seek him out since he last left Honduras. There's no evidence that the gang has contacted his family members or sought to harm them at all. And this is very important because his expert witness testified that a primary way that the gangs would communicate, a primary way that the gangs would communicate threats to an individual that they were interested in or seek out an individual that they were interested in was to communicate threats to their family members. And so the absence of any threats, despite numerous letters of support from family members and friends in the record, shows that the record simply doesn't compel this high standard for cat protection. Furthermore, as part of the more likely than not inquiry, the agency also looked at relocation and found that there wasn't sufficient evidence provided to show that the petitioner could not relocate, that he had not tried to relocate to a safer area like Tegucigalpa, that he had relocated within this dangerous department that he lived in, but he had not tried to relocate elsewhere that could be safer for him. I believe the expert witness did talk about how there were areas where there was better police protection, there was more effective police. Further, with respect to acquiescence, what we're looking at here, really, it comes down to the substantial evidence standard. The record does not compel the conclusion that the Honduran government would acquiesce to his torture. While the petitioner did testify that he witnessed gangs and police inclusion, gang members giving drugs to police officers, there's also ample evidence in the record showing that the Honduran government has truly cracked down and made a difference in police corruption and criminal violence. When this court is looking at its standard of review with respect to the acquiescence inquiry, it's looking for is there substantial evidence in the record supporting the agency's decision. The government's position is that here there is ample country conditions evidence showing that the Honduran government has done a fairly good job at cracking down on gang violence. It's not perfect, no, but the acquiescence standard requires more than the unable or unwilling analysis. It requires that a public official prior to the torturous activity have awareness of it and breach his responsibility to intervene. And the evidence, I see that I have run out of time. So thank you, Your Honors.
Thank you for your argument today. We'll now hear from the petitioner's attorney. 2 minutes.
Thank you again, Your Honors, and forgive me for going quickly. First, regarding the absence of any threats being evidence of anything, I'd like to point out that again, that on remand, the judge closed the record. No, there was no opportunity to present any evidence of any continued contact. And that's why we don't know if maybe they did or maybe they didn't, which is another issue that we raise in our appeal. As far as the distinction on former and current, yes, that is significant. And Your Honor is correct that that is something added for purposes of immutability, because otherwise you can just quit, change your job. But in this case, it is superfluous, as we argue in our brief, because of the fact that he stopped driving is actually the cessation of cooperation. That's what actually gives him the immutability needed in this case. So
isn't it incumbent upon you to define the PSG that way then? If it's superfluous, then why did you include it in your definition?
I was not the attorney that represented him at the time.
Why,
It's okay.
why did his attorney include it?
Your Honor, I'm not sure why that is, but
we're stuck with it, right? Well, you can't change your PSG on appeal once the board takes issue with it.
Correct, Your Honor, but I think that the immigration judge in the first instance correctly interpreted it and actually found what we're really getting at. The asylum statute doesn't require you to spell out word by word what your particular social group is. It just requires you to explain what is the characteristic that you have that is going to subject you to persecution. And obviously the immigration judge felt that the petitioner sufficiently did that when she granted relief in the first instance. And then the board undid everything and undid so incorrectly. And then it sent it back for the wrong standard, and the judge closed the record. So that's where we are right now, and we ask for your help. Thank you for your time.
Thank you, and we appreciate your arguments today, Ms. Stokas. We hope that you get well soon. Appreciate the extra effort you made to be here today and recognize the travel that Petitioners Council made. So thank all of you. Normally we come down and shake your hand. That's the practice, but we're not doing this in this season because of COVID, which is very aptly illustrated by the council here today of the danger that we face. So, but thank you for being here.
Thank you, Your Honor.
We will move to the next case. Stonehenge Lake versus Cincinnati Insurance Company. Mr. Murphy, you may proceed.
May it please the court. Good morning. The appellant Cincinnati and Builders Mutual are asking this court to reverse the district court's grant of summary judgment to the homeowners and remand this case for entry of judgment on several particular or discrete coverage issues, which I'll get to hopefully in a moment, and for a trial to allocate the covered versus non-covered damages, both with respect to the phase 1 judgment that was entered and has now been finalized by the South Carolina Supreme Court, and the phase 2 stipulated damages pursuant to the settlement agreement between the parties.
What's South Carolina telling us in this case? I mean, we got this reservation of rights. You got the Hollisville case. Looks like it's pretty clear. Then you come back and, say a few other things. So where are we on this?
Well, the Harleysville case, even standing alone, really doesn't apply in this case because the legal argument that's been recognized in South Carolina for over 100 years that coverage, that waiver, the doctrine of waiver cannot operate to bring an excluded risk within the coverage was never raised in that case. They simply argued factually whether the reservation rights letters might have not included what they should have. The South Carolina Supreme Court clarified part of that. The settlement agreement cured part of that, but that's part B of the equation. Part A of the equation was never relied on in Harleysville, and the district court assumed that it was and granted waiver as to everything. And I would simply say that the South Carolina Supreme Court explained it most recently in 1966. I'm going to read that quote in just a moment. Through 3 district court judges have applied that rule in the last 12 years in South Carolina in cases cited in our brief. And it's been followed in the liability context. And even though some of the historical cases were more in the life insurance world, Pitts versus New York Life is the case I'm quoting. And it said specifically, the doctrines of waiver and estoppel cannot operate to bring excluded risks within the coverage of an insurance policy, but the doctrines may be applied to forgive conditions which would otherwise cause a forfeiture of the policy. It appears in Harleysville, there was some idea that perhaps an unallocated verdict was going to be forfeited because the out of jurisdiction cases that our Supreme Court referenced in that case would hold that if it's not allocated, it's not covered. Therefore, you have to really make sure you let the insured know what they need to do to cooperate at the trial of the first case.
Turn to that Harleysville case. I mean, I
Yes.
realize you read it in a different way, but the language is pretty strong there. Then you get ex parte builders, and do you maintain to some extent that ex parte builders in any way overruled Harleysville?
It modified it and clarified it in a couple of respects with regards to the grounds for waiver. But the point that I would like to emphasize is the Harleysville case does not reference 100 years worth of cases that stand for the doctrine that I just read. It cannot be read that way.
We can't do anything about that, right? I mean, we're not the South Carolina Supreme Court. Maybe the South Carolina Supreme Court was wrong to not acknowledge 100 years of precedent when they wrote Harleysville, but we got to deal with what they gave us. We can't just say, well, they didn't think about it in Harleysville, so we're not going to follow it.
Well, and that's not what we're arguing. We're arguing that a close review of the case,
A lot like that's what you are.
a close review of the case reveals that the Harleysville did not avail itself of a legal argument that it had. No different than a defendant who fails to raise the statute of limitations. You can't raise it on appeal.
Well, there have been a couple of district court cases in South Carolina subsequent to Harleysville. Have any of them bought your argument?
I'm not familiar with any that have applied Harleysville in the same way that the district court did in this case. And I think the ex parte case goes a long way to saying it was an overreaction. But again, the first part is that the doctrine that we talked about was not argued in the Harleysville case. And even Judge Duffy in 2009, in a case we cited, said South Carolina courts have repeatedly and explicitly held that waiver cannot create coverage and cannot bring into existence something not covered in the policy. That legal argument does not appear anywhere in Harleysville. I've read every brief, I've read every pleading, and although it's mentioned in an appellate brief on page 54, and we acknowledge that, it was never ruled upon by the special referee. The case really just stands for the fact that under the very lenient appellate review in South Carolina, was there any evidence to support the finding of waiver, which is part B? If you looked at the Laidlaw case, they said, even if Aetna waived its right to deny coverage, so in other words, even if part B is there and there was a waiver under the Harleysville standard, then the argument fails because waiver cannot create coverage that otherwise wouldn't exist.
Everything you're giving us is wonderful, but there's nowhere in Harleysville. You got to try to find that. You got to know some South Carolina law and come to that conclusion. And I don't know what we are as a federal court, how we look at a state court. I'm going back to Judge Rushing case, but was stuck with it. And I know your opposing counsel can get up and says that inadequate reservation of rights letter is sufficient for waiver. That's what Harleysville says on its face there now. All the other stuff it should have said, could have said, what it affects. We write opinions all the time that have tremendous effect, and it's horrible, the effects of it. I mean, Supreme Court does it, and they come back and recognize it later on, but I don't know what you're asking us as a federal court to do about a South Carolina opinion that basically you're characterizing as that opinion wasn't a very good opinion. It did not address the issues that it should have addressed it.
Well, it's not that the opinion didn't, it's that the parties didn't. Parties have to raise the issues that the Supreme Court couldn't address this Laidlaw argument.
At all. Ultimately, it's not a question of the parties. We don't go back and read what the parties do. We read opinions. And the South Carolina Supreme Court gives the opinions, not the parties. And we don't read parties' briefs to say, well, this is that, and the Supreme Court meant that. We follow the South Carolina Supreme Court law as being the law of South Carolina.
Yes, sir.
But I think you can move on from this issue. I don't think you have to rest on that alone, do you?
No, because even the deficiencies that were noted in Harleysville don't apply here. So the
That's
ex
where we
parte
should go
case
with this.
has removed them. I don't think we even get to that, but if we do get to that, the fact that the allocated verdict, and this is why you can see what they were fixated on. There was no need for an allocated verdict in this case. The court in Harleysville also went on to talk about how speculative it would be. Ex parte says it's not speculative. Our district court wouldn't apply the Sims versus Nationwide case. The ex parte builders mutual case made it clear that is still the law and that this is how we resolve coverage disputes in South Carolina by a subsequent declaratory judgment action, a phrase that the ex parte opinion uses at least 6 times.
So I have a question about that because
Yes.
Harleysville seems to have this first set of reasoning that says it's not enough to have a cut and paste letter where you just point to certain exclusions and you don't have a discussion of the grounds for it. They distinguish the punitive damages in that letter. Then they move on and say, also, you should advise the insured about this allocation problem, the conflict of interest. Ex parte builders cuts back on that second part, right? The allocation, the conflict of interest, but doesn't seem to touch the first part of Harleysville, the problems with specificity in the letter. And so is that still the law? I think it is. And how does that apply to the letters in this case?
Well, again, in that regard, that is still overlooking the legal argument that wasn't made. The court wasn't ruling on the legal argument in Harleysville. They were just ruling factually. I believe the specific deficiencies they found are more the later ones that include the potential conflicts of interest and not just a cut and paste generic letter. In this case, the district court really didn't find what constituted the waiver, just said that there was a waiver. And because some of the things that were specific and expressed in the Harleysville case were not mentioned. I would like to point out that some of those deficiencies also were cured by the settlement agreement. The parties entered into a settlement agreement to litigate the phase 2 damages separate and apart, and the insureds were fully protected and exonerated. It was clear error, even if Harleysville is broad as is being argued by some, to apply it to a stipulated amount of damages between the insurers and the judgment creditors, so to speak, with the insureds being fully protected. That would also apply to the phase 1 breach of fiduciary duty judgment against Rick Thomas, because he was likewise protected personally from that judgment with respect to phase 1. So no matter how broadly you apply Harleysville, it had no application to those 2 specific coverage issues, which were fully agreed upon by the parties. And, Stone Ledge relinquished its right to argue these things about waiver, but then they abruptly changed their position and renounced that when the Harleysville decision came out. But those have no of the considerations that would have been reached in Harleysville because there was no ongoing exposure to the insureds in that case. There was also a little confusion, Judge Wynn, to help divine what our Supreme Court may have been doing. They had 6 different construction defect coverage opinions in the early 2000s on 3 cases. One of them was Newman, and in that case, they applied a forfeiture in favor of coverage for a non-allocated arbitration award. That was modified, essentially overruled by the Supreme Court in the Ex parte Builders Mutual. So when you see what the Supreme Court did in the Ex parte Builders Mutual for a procedure, and there was no argument that waiver can't create coverage made, a legal argument. Factually, it appears Harleysville just said, well, we didn't waive anything. And the special referee said you did. And the Supreme Court simply said, based on this record, we affirm that a waiver existed. There was never an argument that it doesn't matter. And again, in Laidlaw, they didn't even address the sufficiency of the reservation rights letter because they said it doesn't matter. Even if they're insufficient, they can't create coverage in this particular matter. In the Harleysville case, it appears the Supreme Court was focused on the position that an unallocated verdict would not be covered at all. And they have clarified that there's not a windfall for the judgment creditor and there is not a forfeiture for the insured in that situation. The Ex parte Builders Mutual case made that clear.
Can I ask you
Yes.
This is a hypothetical question. just don't get upset. But if we think that there's a reservation of rights problem here and that Harleysville applies, does that resolve the entire case? Or are there still, even if the reservation of rights letters were inadequate, would there still be additional issues left for us to resolve or for the district court to resolve? I was a little unclear following the district court's reasoning.
As I mentioned earlier, there are at least two issues that the Harleysville case would not have applied to, and those were issues resolved in the settlement agreement. That had to do with stipulated damages as to phase 2 and in effect releasing the insured from any further exposure. They're not liable. There's no.
But are those issues we have to deal with today?
If you could, yes, you could if you piecemealed. I think she's wrong outright and the whole case should be remanded. If you felt like the reservation rights letter issue was insufficient, it was cured by the settlement agreement on those two issues. So you could remand at a minimum those two issues.
The district court said that the reservation of rights letter that applied to the phase 2 issues also.
Which is clearly erroneous without ex parte builders mutual and without doing a little bit of a deeper dive into the Harleysville decision to see that the legal argument that's been around for 100 years in South Carolina was never mentioned.
Well,
All right, we'll hear from the appellee, Mr. Lyons.
Thank you very much. May it please the court. Obviously, we believe that Judge Hendricks' ruling should be affirmed. We think that she did an excellent job, as her orders make clear, that she applied the law of South Carolina as it existed at the time these motions were argued, correctly applying Harleysville, and correctly concluding that the deficient reservation of rights letters waived Cincinnati and Builders Mutual's coverage defenses to the case. As she noted particularly in her response to their motion for reconsideration, their arguments express a lot of frustration with the Harleysville decision, which this court has also addressed this morning. And I don't want to belabor that point. But Harleysville is the law of South Carolina. And from my perspective in Builders Mutual, the Supreme Court had an opportunity at that time to limit Harleysville, to explain how Harleysville was limited to a certain set of facts, to say what it didn't apply to. They could have addressed the Laidlaw decision. And I'd also point out to you that in the Builders Mutual case, if there was any question about what arguments were considered in Harleysville and which weren't, Mr. Murphy was the lead lawyer for the appellant in the Builders Mutual case. And Laidlaw, again, is not mentioned in that case. And I think that's because it's not relevant. Our Supreme Court was clear. Judge Hendricks recognized that her obligation was to follow South Carolina law, and we think that she did it. And it's as simple as that. And this case presents a unique opportunity to see the importance of that law. I'm a trial lawyer more than an appellate lawyer. And when we get in appellate cases, we discuss a lot of things in the context of more intellectual approaches to these legal questions. But the things that concern the South Carolina Supreme Court in the Harleysville case happened in this case. Defense counsel hired by Cincinnati and Builders Mutual allocated the damages in the trial court, not between what's your work, what's not your work, what may be property damage, what may not be property damage, but allocated them among the causes of action. That's what they did. And now in this case, for going on 8 years now, Cincinnati and Builders Mutual have said, you know what? We don't have coverage for 2 of the 3 causes of action that the jury allocated damages to our insureds. And so exactly what Harleysville was worried about happened in this case.
What about the punitive damages provision there? Harleysville upheld that. And when you look at that provision and the letters at issue here, they look just about the same thing to me. Isn't it fair to say that Harleysville was mainly concerned with particularly generic denials of coverage? The letters here aren't generic. They cite to specific provisions. Is that correct? Or how does that work?
Well, I think that the letters here were generic, and I think that's what Harleysville was worried about. And I think what Harleysville carved out for us was they said, they took a careful look at the reservation of rights letters, and they did note that they thought that the reservation of rights letters in that case did sufficiently address the punitive damages issue. Here, there's no punitive damages at issue. What here we have is this, for example, the known loss issue that's come up, never mentioned in the reservation of rights letter. They're taking the position now that there's no coverage for Merrick on the breach of warranty claim, just no coverage for it, not mentioned in the reservation of rights letter. They're taking the position that Mr. Thomas has no coverage on the fiduciary duty claim because his duties as a board member were related to his activities for IMK, which is not an insured, never mentioned in the reservation of rights letter. And the lawyers that they hired to defend Merrick and Mr. Thomas moved to separate out that jury verdict as they did, allocating damages to specific causes of action, which they now say they have no coverage for. And it's worth reflecting on the record a little bit. I tried to correct that at trial, and the trial judge agreed with me. We took the entire amount of the judgment, we allocated it equally among each cause of action, and then gave all causes of action the benefit of the set-off to try to level the playing field, if you will. They opposed me from 2013 on that issue all the way to 2020 when we argued this case in front of the South Carolina Supreme Court. And the defense lawyers hired to defend Mr. Thomas stood in front of the South Carolina Supreme Court and told the South Carolina Supreme Court, you should take the set-off, but don't give the fiduciary duty defendants any benefit of the set-off. And Justice James looked at the lawyer for Mr. Thomas and said, don't you represent Mr. Thomas, who's one of those defendants? And he said, yes, sir. And Justice James just sort of scratched his head. That's what happened. Those lawyers unevened the playing field for the insured in this case.
Can you talk about the settlement and whether that agreement between the parties changes how or if we apply Harleysville to phase 2 or to the fiduciary duty claim?
Yes, ma'am. I don't think it has anything to do with the application of Harleysville at all. As Mr. Murphy said just a moment ago, what we did 3 years after the trial of phase 1, we were finally able to get a trial date for phase 2. By that time, this case had been pending in the district court for 2 years, and we were already arguing about coverage. And what we decided was to agree upon what the damages at a trial would be if we tried the case. And then we agreed that we would assume that any verdict would be reduced by the by the settlement sums that we had received for phase 2. And we came up with a net anticipated verdict, if you will, of $2 million. And we both agreed to live with those damages in the context of this coverage case. There was nothing about that agreement that changed any of the coverage positions. And this idea that Mr. Thomas was somehow released or that judgment just goes away is just not true. In fact, a month ago, a South Carolina Circuit Court judge agreed that the judgment doesn't go away. He just entered judgment against Mr. Thomas for $1 million, believing that the agreement was simply an effort to protect Mr. Thomas personally, but it didn't affect the coverage issues at all. So that is a valid judgment as I'm standing before you today in the court of South Carolina, that $1 million judgment. And no, ma'am, I don't think it affects the Harleysville arguments at all.
You don't have to take all your time.
I won't. And I wanted to tell you I'm excited for your new status. When I heard it, I was thinking I've been trying to figure out how to get senior status in my law firm for about 10 years. They won't give it to me. Anyway, thank you very much.
Thank you. All right, you've got a few minutes for rebuttal, Mr. Murphy.
Thank you, Your Honor. Let me address just a couple brief issues there. We're here to talk about coverage, not about conduct in the tort case, but we do have a Supreme Court opinion that denied the amalgamation sought, which was part of the only basis apart from waiver that the district court found coverage for breach of fiduciary duty. And so there are two things that make that ruling wrong. First of all, there could not be a waiver on that because the settlement agreement, most assuredly, and we have laid this out in our brief, gave Mr. Thomas, who was a principal both in the general contracting company, Merrick, and this newly formed LLC to serve as the developer and oversee the board before it was turned over to the homeowners, kind of a common thing, that he is fully protected from any effect of the phase one judgment. And whether that judgment was then further released is being argued in South Carolina. A trial court said the judgment's still there. But even if the judgment is still there, Mr. Thomas was fully protected. It will not be executed against him. And the key to that in coverage is therefore he's not prejudiced. And so the settlement agreement cured any deficiency in the reservation of rights letter, just like it did with the phase two damages, because those damages were between the carriers and the judgment creditors from phase one. There was no possibility that they would ever apply. The carriers stepped in and did the right thing and are willing to pay what their share is once they get a fair trial on allocation. So if there were any deficiencies, which again overlooks the fact that you can't create coverage with waiver, can't use that doctrine, really wasn't even pled affirmatively in this case. But those two issues are certainly subject to remand, entry of judgment on the breach of fiduciary duty, because the Supreme Court has now said there is no amalgamation. So Mr. Thomas, even if he's wearing two hats, it's not covered. The fact that he was just wearing one hat for this new LLC that created and controlled the homeowners board prior to turnover to the real individual owners, that ends any possibility of coverage for him. This case should be at a minimum, first thing, remanded for that judgment to be declared not covered. Secondly, for a trial on the allocation of phase two. The carriers are not taking the position that the breach of warranty, South Carolina law is kind of clear the way it imposes warranty liability, and so that's not true. And then with regard to no loss, you don't have to issue a reservation of rights to tell someone what's going to happen in the future. The lawsuit was filed in 2009. The first reservation of rights letter from Cincinnati referenced policy periods that went from 08 to 09, 09 to 2010. There is an issue of fact as to whether or not the insureds knew about the lawsuit and not the lawsuit, but the claims that were being made prior to April 1 of 2009. That would be an issue of fact that would need a remand for trial. The 2010 and 2011 policies, there's no basis to find waiver because that was a future event. The lawsuit had been filed. The policies were in the insured's hands, and there's no duty under any case that's ever been argued. You have to reserve your rights as to future contingencies. Plus, the insureds never came back and asked for coverage under any subsequent policies, and the reservation rights letter in the record said coverage may apply on the policy through April 1 of 2010. In other words, the first two policy terms of 4 Cincinnati policy terms. So the waiver arguments are not applicable to known loss under the last two policies. They're not applicable to the breach of fiduciary duty, that being cured by the settlement agreement. They're not applicable to the phase stipulated damages.
Hey, on that known loss, you didn't mention that specific provision in your reservation of rights letter. Why is that not waived in the policy?
It might as to, even though you can't create coverage by waiver, but if it wasn't mentioned in the original one and is waived, it can't be waived to the future events. Because obviously, if you have a lawsuit in 2009, you don't need to be told that the policy that comes into effect a year later might cover you for something you've already been sued for. I mean, that part of it is to apprise them of what might be there. They would have the policy at that point. They would know about the lawsuit. They didn't take any detrimental reliance. And of course, that's really at the gist of Harleysville appears to be more of an estoppel argument, because the prejudice and the failure of the insureds in those cases to do something after the loss. All of the coverage issues in this case have to do with issues and facts that had already existed at the time the lawsuit was filed. They don't have anything to do of an insured being unwary about something and then taking a detrimental position in the trial of the case. For example, Mr. Thomas, whether he was on the board through his role with the developer LLC, that was already clearly established factually. So there would be no prejudice on an ROR. And that's why the Harleysville case really should have a limited application. And Judge, when you asked me at the outset, what's the South Carolina Supreme Court wanting to tell you? They're wanting to tell you that this case should be resolved on the merits of these coverage issues, not on a technicality. Because for 100 years in South Carolina, you can't get coverage out of thin air because the reservation of rights letter may have had a few deficiencies. You can waive the requirement for a proof of loss in a property claim. You can waive a condition that you would forfeit the coverage because the insured didn't cooperate with you or didn't give you a sworn statement. You can waive those conditions that would evoke a forfeiture because they involve conduct that occurs after the loss. But if you go back and look historically at these cases, you can't pull coverage out of thin air. If the policy
asked for a certification of this issue.
We tried and we got denied on that. I would not think that would be inappropriate for this court if you're struggling with the breadth of Harleysville. I'd rather have it clarified with the money at stake in this
I
case.
have some clarity on it. South Carolina has kind of thrown us something here.
They've thrown you a curveball. With one anomalous case, I would argue, and 100 years of cases that are very clear.
All right. Thank you very much for your argument, gentlemen. You know that normally we come down and shake your hand. That's what we do as one of our courtesies. Not doing it today because of obvious reasons. Hopefully we'll be back in session doing it again when we come back in the near future. Thank you and have a nice, safe, enjoyable trip.
Yeah, fine.
We will move on to the third case, GT versus the Board of Education. You may proceed.
Thank you, Your Honor. May it please the court, I'm Richard Boothby of Bowles Rice. I represent the appellant, Kanawha County Schools. We're here because the district court certified a 23B2 class of students who claimed that Kanawha County Schools has an inadequate system of policies and procedures for the creation of effective behavior supports. Because the district court abused its discretion in several ways, we ask that you reverse that certification order and that you remand the case just to consider the individual separate claims of KM and GT. The district court abused its discretion in at least 4 ways. First, the district court approved common questions that turn on the expert's opinion of whether the school board's policies are adequate rather than compliant with state and federal law. An expert's opinion on what is adequate cannot settle the legality of the school board's conduct and therefore cannot drive class litigation forward. Second, the district court abused its discretion by finding that A2 commonality may turn on, quote, quality of evidence, supporting a cohesive pattern of adequacy. Inadequacy cannot be enjoined or declared illegal. Third, the district court abused its discretion by certifying a B2 class that seeks unspecified, systemic reform of Kanawha County Schools' entire special education program, not through final injunctive relief, but through a process of continual improvement. Fourth, the district court abused its discretion by relying upon the clearly erroneous factual finding that Kanawha County Schools has the highest suspension disparity rate in the state and one of the highest among large schools nationally. There's nothing in the record to support that. A free, appropriate public education is the yardstick by which all the adequacy of Board of Education decisions are made, and it turns on individual student needs. Every IDEA case, including this one, is supposed to be about whether a school district provided a student or students with a FAPE. Plaintiffs argue this case is about a local school board's legal duty to create policies and procedures for the provision of effective behavior supports. As a matter of law, the school board has no legal duty to create any policies or procedures. It must follow the state's education policy. The idea that the type of evidence offered by the plaintiffs in support of class certification, a pattern, a practice of inadequacy, ineffectiveness, or even impropriety has consistently.
That's a key point, case, what you just mentioned about the not having a policy. Opposing counsel seem to indicate you do have some duty to enact a policy. If you don't do it, then how do you know you are meeting your statutory duties and stuff? I mean, it's one thing. I guess to follow where you're going is, why would you ever enact a policy if you're going to be held to a policy? So you just won't do it. So I don't know. Is that what you're advocating? That you would never, anybody in this type of situation would never enact a policy because you don't have to, and if you do, then some liability could attach to it if you don't follow that policy.
No, Your Honor, under Section 1412 of the IDEA, Congress was clear. The state education agency, here the West Virginia Board of Education, has a legal responsibility to create all policies and procedures that comply with a very long list of requirements. When you go to Section 1413 of the IDEA, you find out that local education agencies, which is what we are required to adopt policies that comply with the state's policy. In West Virginia, every county school board follows the state's policy. In the joint appendix at 948, you'll see the first or second page of policy 2419. That's the policy we follow. And in about the second paragraph near the end, it says, I'm paraphrasing, that this is your procedures and policy manual, and you will not change it without our permission. The legislature went even further. West Virginia Code 1820-5 subsection A3A states, no school board or the state board will adopt policies and procedures under IDEA that exceed the federal requirements.
So the question is that a merits argument? In other words, whether these policies are actually required under IDEA, how does that weigh on commonality?
Well, there are two answers to that. The first one is that any rigorous analysis of compliance with the rule, because the rule is not a pleading standard, the rule you have to adduce evidence that you're complying with the rule. Some of that inevitably, as we learn in Walmart, is going to involve looking at the merits. The second answer is, until the brief in this court from the plaintiffs was received in February, the plaintiffs had never made that argument before. This is our first opportunity to respond to it. However, whatever rigorous analysis of Rule 23 means, it surely means taking a look at two statutes and reading the first two sentences. 1412, state obligations. 1413, LEA obligations. We follow the state's policy. We're not required to draft our own. The IDEA class action, the court's rigorous analysis of compliance with the rule must include a finding that the IDEA was violated. And that can be made as to the whole class in a single stroke, resolving the central issue: was the law violated? An IDEA class action could not proceed otherwise. The district court confirms the necessity of finding a class-wide fate determination at JA 1595. Where it states, whether the plaintiffs ultimately prove that KCS is not providing a FAPE in the least restrictive environment to the class members remains to be seen. So there's no question that as to the whole class, there's a question of FAPE. The judge would have been more accurate to have said a violation of IDEA. One of the points that the plaintiffs make or suggest is that we're saying they have to identify every harm, or we have to make them identify every harm that's going to happen as a result of the alleged inadequacies or ineffective policies. And that's not what we're saying. What we're saying is they have to be able to show in a single stroke that whatever it is we did, it violated FAPE as to every member or no member of the class. And that's why Jamie S. and City of Springfield, the First and Seventh Circuit Courts of Appeal, have formulated it this way. In a IDEA class action, Rule 23B2 class, you have to allege that the school district, excuse me, the school district is starting with a policy or a well-established procedure that says, we're not going to do this. And we're not going to look at your individual circumstances before we make that decision. That would violate the IDEA. That would not necessarily mean that every student in the class would end up with a denial of FAPE. There can be procedural violations of the IDEA. In other words, they could violate the IDEA, but certain members of the class would never suffer any denial of FAPE. I'll give you an example. If a school district said, we are not going to provide you with any speech services for the first 3 weeks of school, we're just not going to do it. That is making a decision about what a child will receive without considering their personal circumstances, their needs, their strengths. And that lack of individual inquiry before denying services does violate the IDEA. However, there may be lots of students in that class who didn't need speech services. Procedural violations of the IDEA are not necessarily denials of FAPE. You have to prove a substantive denial of FAPE. The plaintiff's common contentions below were summarized by the district court and Dr. Elliott, their expert, solely about the adequacy of the procedures that KCS uses or does not use to develop behavior supports and whether they were proper. In the Joint Appendix 1584 and 1585, you'll find no reference to the IDEA. You'll find no reference to Policy 2419. You will find the opinion of one expert being used as the yardstick by which the school board's conduct is being judged.
Were there other causes of action alleged besides the IDEA, like the Rehabilitation Act?
Yes, there were both ADA, Title II ADA and Rehabilitation Act claims.
And the West Virginia Human Rights Law?
Yes, that was in there as well. Although you'll find nothing in the record about that in terms of those claims. Also under Fry, the Supreme Court case, the ADA and Title II, the ADA and 504 claims are subsumed into the IDEA claims, which is to say these are claims they could not have pursued on their own. They could only have pursued these in pursuance of the rights under the IDEA. So those claims are subsumed by the FAPE claims.
Well, what I was getting at is that it strikes me as there are several different causes of action here.
There is one cause of action.
I thought you just told me, all right. I thought you told me that there was also West Virginia human rights. This is not necessarily a question that you're going to disagree with. So maybe you just listen to the whole thing, okay? That because there are the different various causes of action, there are different standards of proof or necessity for proof. And that in itself creates something that cannot be subject to a class action as it was formed.
I hate to make a point for the plaintiffs, but actually under Fry, the FAPE action subsumes all ADA and other claims. In other words, the ADA claims and the other claims are not independent.
Children have different disabilities, arguably.
Yes. Oh, absolutely. They have different disabilities. There's no question about that. It's just that you would have to prove a denial of FAPE. And then that same set of facts happens to also prove a denial of accommodation under 504 or lack of equal access under ADA.
Or what about the West Virginia Human Rights Act?
I have yet to understand how the West Virginia Human Rights Act has any application to this case, and it doesn't become clear in the record. Nothing in the district's order mentions it. Our bottom line is that either KCS complies with policy 2419, the SEA policy, or it does not. After 2 years of discovery, plaintiffs failed to identify a single policy of the board that does not comply with policy 2419 or the ADA. The district court stated this at JA 1589. Using Dr. Elliott's opinion, as the yardstick for determining IDEA compliance and FAPE was legal error for 3 reasons. First of all, as already mentioned, LEAs are required to follow SEA policies and procedures, not conform to best practice as determined by one expert. As this court has held for decades, in IDEA cases, absent a statutory violation, the task of education belongs to educators. After 2 years of discovery, we have yet to hear what the statutory violation was. Again, though, in February of this year, for the first time, in an interlocutory appeal of a class certification order, the plaintiffs alleged that the Board of Education has its own independent duty to draft policies under 1412 and 14 I believe 1412, 1415, and 1414. The statute couldn't be clearer. The state drafts the policies, the LEAs adopt the state's policies. That, by the way, is true for every state in the Fourth Circuit. The plaintiffs offered no evidence of statutory violations to the district court. They consistently faulted the board for not complying with their experts' opinion about what policies and procedures would be adequate and would have provided effective behavior supports. It's important to remember that their argument is, but for the school board's failure to create policies and procedures for the creation of effective behavior supports, unjustified, whatever that means, unjustified student suspensions wouldn't have occurred. Dr. Elliott's opinion about the school board and whether it has adequate or proper policies for the provision of effective behavior supports is not a legal standard by which the school board's conduct may be judged. Thank you. The district court got this exactly backwards.
If you want to continue, you can, and you want to shift some time from your rebuttal.
Yeah, I think I would shift 2 minutes from the rebuttal. Secondly, the quality of evidence of patterns and trends in data observed by an expert do not show and cannot satisfy commonality under Rule 23. The district court's contrary conclusion is a legal error and abuse of discretion.
Can I ask, has there been any talk of subclasses in this case or not?
Other than in a couple of the briefs and some mentions, no. Thank you, Your Honor. In Jamie S. and in Springfield, the First and Seventh Circuits, these are cases cited by the district court. These are cases that found a formulation, that is, a way to apply IDEA within the context of a Rule 23 B2 class. The court cited both those cases and then came to the exact opposite conclusion of what those decisions were. In both of those decisions, the courts rejected the idea that an expert could look at some files, develop their own personal opinion that, well, that denies FAPE, extrapolate that out over the class and say, that's the commonality. Our expert says you denied FAPE to all these people. That's not what Jamie S. said. That's not what Springfield said. But those are the decisions cited by the court. That's legal error.
So you do concede that you could perhaps have subclasses that have the requisite commonality?
No.
Well, that seemed, you are relying on cases which did do that, right?
Well, as a factual matter, no, because here the issue is whether or not we have a legal duty to write behavior policies, and we don't. Under either of those cases, what you're looking for is this: something we did to enjoin. The something, according to those two courts, is this: denial of services across the board, and we don't look at your personal circumstances. We just say we're not going to do it. That is a denial, or that is a violation of the IDEA. As to some class members, there may be harm. As to others, there may not be harm. But if that procedural violation of the IDEA results in a substantive denial of FAPE for a student, then that would violate it. And that's why the courts began with that. Whatever it is they're alleging has to resolve an issue. Its importance is that if we can decide that, if it's true, if it's false, yes or no, then we will know in one stroke that the defendant's conduct is illegal. It should be enjoined as to the whole class or none of the class. And that's not what we have.
All right, let's get to the other side of the case, and we'll give you some time for rebuttal.
Thank you, Your Honor. May it please the court. Most of what we've heard from KCS today relates to how the IDA does not place affirmative obligations on it to create policies or to be responsive in the area of behavior supports. You know, they're saying it's the state's responsibility, or it's the principals, or it's the schools, or it's the IEP teams. We think that's absolutely wrong, and I'm happy to explain why. But I think the more fundamental point, as Judge Wynn pointed out, is that's a merits question. You know, their argument all down the line has been, we actually do comply with the IDA because we do have really great policies. We secure the fate that students died through each of these policies. We train people adequately. Now in the reply brief, they're saying we don't really have to do policies at all. In fact, you know, it's really just the state. There's no legal obligation here. But those are just different ways of trying to attack the merits. Either way, they're sort of arguing that they don't have an obligation under the statute. But that is exactly the kind of common contention that can be resolved on a class-wide basis. As Walmart put it, determination of its truth or falsity will resolve an issue that is central to the validity of each one of the claims in one stroke. If they're right about that, if all the arguments they've made here in their reply, but if they're right, then every class member's claim is going to fail. Of course it is, because the claim is based on the failure to provide these adequate responsive policies. If they're wrong about that, that's going to advance every class member's claim on the merits. And it doesn't have to resolve liability for each one of those claims. It just has to be a single question of law or fact that provides a common answer that drives the litigation forward. And I think basically everything we just heard underscores why this is the kind of case which should be handled on a class basis. And this exact question should be handled in one stroke rather than in 1,000 individualized hearings where you're essentially asking the same question about whether or not KCS is doing its job.
So what is one question that is common to this whole class? In your brief, you gave me 5, but I'm not sure that any of them apply to everyone. So what's one question that's common to all members of this?
Well, I mean, I think the easiest and most straightforward one is, you know, under 20 USC 1413A3, the local education agency shall ensure that all personnel necessary to carry out this chapter are appropriately and adequately prepared. So that's a training provision. And our allegation and Dr. Elliott's report says that there's basically no structures in place for training, that the training is inadequate across the board. And that's clearly an obligation, a statutory obligation that's placed on the LEA, and they fail to do it. And we only need one common question. So training alone, the inadequacy of training alone is a common question that can be resolved on a class-wide basis. But
so
there are
training for what?
Training to address behavioral support. So I think the problem is that system-wide, you know, children acting out aggressively as a manifestation of their disability, and system-wide at KCS, no one really has any idea how to handle that. You know, there's no
training to identify students who need behavioral supports, or training to implement behavior supports for children who have already been identified as needing it, training to track their progress. What's the training?
I think that it can be training in all of those areas.
Because those are different children, right? And your lead plaintiffs, for instance, were identified as needing behavioral supports, and they're written into their IEPs. So some of your questions you've identified don't apply to your lead plaintiffs. They were identified. They have them in their IEPs. They're being tracked. I'm just trying to figure out what's the one question that would actually apply both to the lead plaintiffs and to everyone else in the class, not just policies in general, but it needs to be one question that applies to all these children. And these other courts have noted that when you're looking at multiple steps in the process, you're identifying different questions, not one common question. The common question can't be, is the whole process flawed? It has to be more specific than that.
Absolutely, Your Honor. And, you know, so with respect to training, if it were the case that there was proper training about behavioral supports, then there may be other things downstream that may lead to someone not getting FAPE or other problems. But we just have to identify that one question. And there's clearly a statutory obligation on the LEA to do that. So the question is whether it is complying with that. And we have evidence, you know, for example, in Dr. Elliott's report, she says there's a common method called the WVTSS, the tiered system of support, which is a sort of common way of addressing.
If if we were to affirm in an opinion that says this class has identified one common question and only one, and it is training, and we send it back and your whole case is about training and nothing else, that would be okay with you?
No, Your Honor, I'm happy to talk about other areas, but I think that it would just be a straight affirmance because we only need to identify one common question. And it's up to the district court, I think, if it wants to address other things sort of on within the context of a certified class. The question is, should the class be certified? And if we identify one common question, the class should be certified. Now, there might be, many supplemental litigation questions about the remedy, what might happen and how the class is going to proceed. But all we need is one common question under the text of Rule 23A. But I'm happy to talk about, other provisions. For example, with respect to monitoring, 1414 and 14, I should note, they talk about 1412 and 1413. If you look through 1414, which is sort of the font of the actual substantive obligations that the IDA has, it over 20 times it mentions the LEA shall ensure. That shall ensure language is the key. So for example, in the provision I just quoted, D4A, the local education agency shall ensure that the IEP team reviews and revises the IEPs, and then it discusses behavioral supports. And the key point there is the LEA is the proper defendant in all of these lawsuits. If you had an individual lawsuit, you'd be bringing it against the LEA because it's the LEA that ultimately is the backstop, has the ultimate statutory responsibility for ensuring that the provisions of 1414 are actually being properly complied with.
That leads to an opportunity for you to respond to the reply brief on what, what you've said is the merits question about who has the obligation for the policies. Because I think their response is, sure, we are responsible for ensuring each child is getting a safe and the least restrictive environment, but we're not responsible for the policies. And if your whole case is now about who writes the policies, we're not responsible for that. So I wanted to give you an opportunity to respond to that since that came up in the response and reply.
Right, Your Honor. So, we're not saying there's some freestanding, statutory obligation to create policies, but there is a statutory obligation to ensure that all of these things are happening. And
it's not about writing the policies. It's just about giving a faith.
It is just, no, it's not about giving a faith. It's about ensuring that the provisions of the statute are being met. And it's just,
it's about following the policies.
What an LEA does fundamentally, you have a decentralized system where you have hundreds of different IEP teams, schools, entities. The only way in which an entity can ensure that something is happening within those decentralized systems is by, number one, monitoring and trying to figure out what's actually going on and collecting adequate data to see if the provisions are being complied with. And then number two, having something in place for figuring out what to do when they're not being complied with. And that's a policy. And, the idea that an LEA doesn't create policies, I just think it doesn't make sense to me. An LEA's fundamental role in the system is to create policies. If you look at the first line of the KCS website, it says,
hi.
So sorry, Your Honor.
I'm not trying to argue with you. I'm trying to find out what your response is to their statutory and regulatory argument. They say this regulation says state makes the policy, and our state has told us not to change the policy without the state's express approval. And I just want to know, do you agree that's a right reading of the regulations and the statutes, even if your argument is, yeah, but you need to have other policies to actually make it work? What's your response to what they said in the reply?
They cannot, I think that it's true to say they cannot have policies that conflict with state policies, but the state policies themselves contemplate that the LEA is going to be the entity that's going to be implementing a lot of these things through their own policies. So for example, if you look at policy 2419 and it's in the JA, so at JA 1032, for example, it says it's an LEA shall develop, implement, and revise district improvement plans, and when found to have a significant discrepancy, review and revise policies, procedures, and practices as necessary to ensure they're in compliance with the IDA in relation to, and then that says the use of positive behavioral interventions and supports. At JA 1013, county boards of education are required to incorporate and implement in schools a preventive discipline program, which may include positive behavioral interventions and supports. So all of these things are contemplated in state policy. And then if you look to our expert report, Dr. Elliott, this is at ER 204, page 18 of Dr. Elliott's report, there was little evidence in the records I reviewed to indicate that KCS implements normal and customary policies, such as those identified in policy 2419, including the ongoing collection of student academic achievement and behavior data and assessments of behavior supports based on those data. So our contention is that state policy has required this, and it's briefly mentioned even in the district court's order that they sort of adverted to this idea that really it's up to the state and not up to us. And the district court rightly framed that as a merits question. But I think on the merits, we think we have a very strong argument that KCS absolutely does have responsibilities, both under the IDA and under state policy. One other thing that I wanted to mention, I think that the sort of fundamental thing that the other side said was, it's not clear that every class member is harmed and the effects are different. And I think that goes to some of your questions, Judge Rushing, about, FAPE is going to be different. Each individual is in a slightly different situation. But just because the effects might be different doesn't mean they don't have a common root. And here, it's KCS's failure to meet its statutory obligations that is the common root of all of these problems. And it's resulted in schools across the system, not having really any idea how to deal with children with behavioral supports. And there's no, the idea, I think, then that the solution to that is thousands of individualized hearings where you just change the IEP is what the DC circuit, what Judge Tatel called, preposterous, because, firstly, it's obviously very costly and lengthy, but I think more fundamentally, it just doesn't address the problem. You can make recognized
that there could be subclasses, right? That it may not, you may not have to go student by student to prove the denial of a FAPE, but that, if your question is about this policy or that policy, that a subclass tailored to that policy is appropriate rather than kind of all students who are affected by all bad policies.
Right, and we have a much, here we have a much narrower class because it just relates to individuals who need behavior supports who have been excluded. So it's not trying to say everyone, it's very targeted at the behavior supports issue specifically.
No, you have students who haven't been identified as needing behavior supports and students who have.
I think that,
but haven't received them in a certain way, or who have received them but haven't been monitored. It's, it's small, it's more targeted than some of these, but it's still a pretty big, diverse group.
I agree with that with respect to identification. I think that there is certainly an argument that you could have a subclass of individuals who have not yet been identified, and that's slightly distinct from the rest. I mean, the rest of the class are individuals who are currently, our allegation is, are not having their behavior supports properly implemented, monitored, and they're subject to inadequate training. I don't think, in DL, there was sort of no overlap between the classes. I think that here they would be, I think, overlap between all of those things. That's basically everyone in the class, except for the people who have not yet been identified. So probably two subclasses might make sense in a case like this, but I don't think you would necessarily need 4 subclasses or more. But I think that's a great point, Judge Rushing. I think that, and I think, to Judge Motz's point about the ADA, I think that subclasses could be a solution in other directions. If you really did think the ADA claims were different, the normal way of handling that, I think, would be to have an ADA subclass. I don't think that necessarily needs to happen now. I think you could well, for example, say, well, there's a common question that's affecting everyone within the class, which is the inadequacy of training or the inadequacy of monitoring. We can certify the class on that basis. If you then have questions of remedy or questions of defenses that only go to a particular statutory, a particular statute or statutory provision, then maybe you could divide them further into subclasses at that point.
When it comes to the subgroup, let's say, of students who haven't been identified as needing behavioral supports, don't you have an ascertainability problem as to that group?
I don't think so, Your Honor, because, I think ascertainability with respect to, tracing, that sort of very strong form of the ascertainability requirement just doesn't apply, I think, in a B2 class.
But we've said to the contrary. Both parties cite this EQT case where from our court, and it was a B2 and a B3 class, and we very strongly adopted an ascertainability requirement and administrative feasibility. And we didn't say it differed between whether it's looking at the B2 class or the B3.
You didn't, but I think it would have there was no argument that they should come apart for purpose of that case. And the ascertainability requirement clearly, I think, does apply in a strong form to a B3 class. This court has not said for an exclusively B2 class that it applies, and it would create a circuit conflict with the Third Circuit and the Sixth Circuit if it did so.
But we said, a class can't be certified. We looked at it as an A issue before you even get to whether you're under B2 or B3. I'm just not sure that this panel's free to say we don't have to agree with that.
I mean, I just don't think it was really briefed and addressed in any clear way in that case. And I don't think you should create a circuit split based on that. If you want to sort of address the substance of it, I do think that the tracing requirement doesn't make that much sense in the context of an injunctive relief claim, because the tracing requirement ultimately is identifying people for purpose of damages. You never have to do that. So the idea that you won't be able to identify each individual person, I just don't see that marries up with the purposes of the text of B2. But in any event, as we explain in our brief, in this class, in this case, these are ascertainable people. The question is, are they challenging to ascertain? And they wouldn't be challenging to ascertain but for the defendant's conduct. The whole contention.
The question is, do you have objective criteria to ascertain who they are? And that seems pretty tricky.
Well, I mean, Dr. Elliott's report sets out procedures that other districts and sort of nationwide best practices as to how one identifies people who may require behavioral supports, and explains why KCS isn't doing it. So I think we at least, it's objectively true. There are people out there who need behavioral supports. That's an objective fact. The difficulty of finding them is itself the thing which is being challenged in the litigation. I think in that context, there's an additional reason not to apply any ascertainability requirement. And I think, as you sort of started out by saying, Judge Rushing, even if that was a concern about that, it would only apply to that particular subclass of people. So you could say, well, that subclass maybe is not viable, but the rest of the class would be. And as the district court sort of acknowledged that by saying, we can always adjust the class definition. That's something that is generally within the district court's discretion. So I think if this court wanted to affirm the decision overall, and say, maybe there needs to be subclass in some areas, or maybe there needs to be some modification of the class, I think that's certainly something that would be available. I do think the sort of fundamental question that they're sort of pressed, the idea that everyone just needs to be shown, that it needs to be the same harm that everyone suffers, just isn't part of Rule 23b2. It's not our job at this point to show that everyone is going to have suffered an injury at the end of the day. It's just our responsibility to have a common contention that one way or the other resolves the case on a class-wide basis.
Anything further?
If the court doesn't have any further questions, I do also want to maybe just stress and a couple of additional things about two DC Circuit cases. I think I think the claim here is very similar to that at issue in DL. This question of affirmative requirements is basically on all fours with what happened in DL. Those were provisions of the statute that were the child fine provision, and something that is equally as defendants would suggest vague, which was the smooth and effective transition from toddlerhood to preschool. That was another subclass in DL, and all of those things were basically was the defendant putting in place adequate policies and structures. The DC Circuit found that they could, and there was nothing, hugely problematic about the relief. In that case, the court imposed a range of programmatic remedies designed to improve the district method of finding and tracking children, including requirements the district establish databases, disseminate information, and report its progress to the court. So there's all this concern about how intrusive the injunction could be. That is completely speculative. We don't know what the injunction is going to be until we even know what the liability findings are going to be. It might be that the district court actually only finds liability as to a couple of these questions, and only finds, modest violations, and then issues modest injunctions. It's not really our role at this point to say what the exact injunction is going to be. In fact, it's impossible to do so until there's been further litigation. So I think there is a little bit of scaremongering with respect to the sort of intrusiveness in the injunction. And then they have an immediate appeal right with respect to the injunction. If the injunction is overly intrusive, they absolutely can come back to this court and cut it back. But that's no reason to say that this case just shouldn't be certified in the first place. And I think, ultimately their requirement that, there's got to be some affirmative policy that's subject to class certification. But if you're just sort of doing nothing, as Judge Wynn said, you just don't make any policies, you just sort of abdicate your responsibilities. And that's what we've pled. That's what our evidence shows. That's what Dr. Elliott shows, that somehow you're insulated from class-wide scrutiny. I just don't think that affirmative versus doing nothing distinction makes any sense. But I think ultimately that case really hinges on that distinction in a fundamental way.
Thank you very
Thank you.
much. You have a few minutes for rebuttals.
Thank you. Notably, the plaintiffs in their briefing just now told you to rely on DL. DL does talk about a duty to create policies, practices, and procedures, and that's absolutely correct. The District of Columbia is not an LEA. It's an SEA. That's in the decision. The District of Columbia must comply with 1412. We don't comply with 1412. States do. The District of Columbia and Hawaii are the only two school districts in the United States that are both SEAs and LEAs. We have no problem with DL because it doesn't apply to us. Secondly, subclasses are never going to be appropriate if the yardstick is always Dr. Elliott's opinion and not law. During the presentation you just heard, we heard the words proper, best practice. What you didn't hear was a statute that was violated by the school board. Also, they didn't address any of the abuse of discretion arguments that we raised. Again, as to merits, that's black letter law from Walmart. There's going to be some examination of the merits when you're looking at commonality. It is certainly less than rigorous to have to look at two statutes and realize that one says state and one says local. I don't know that you need to have a trial to determine that. They got into some discussion of training. There are only two kinds of training under 2419. And the word training, I should say, is mentioned 25 times in the policy. There are two kinds. WVDE training, that is training from the State Department, and they provide training on very generalized subject. As to class members, there is no common training. Policy 2419 states that if training is required to provide FAPE to a child, it has to be in the IEP. The training itself is individualized to that child's needs. Some children will need training for themselves, for their parents, for their classroom teachers and their aides. Some will need none of that. So again, you come up against the same problem. No, not all class members are going to need the same kinds of training. There was also a mention about what's appropriate as to BIPs and FBAs. Federal law does not define either term. West Virginia law does. Policy 2419 describes what a BIP is, a behavior intervention plan, and all the elements there are optional. There are no mandatory elements. The Forestville case out of the Seventh Circuit that we noted received a request similar to this to add some substantive requirements to what a BIP is, and their statement was, there's no way to violate the substantive requirements of a BIP. Congress doesn't have any. And so they refused the invitation to make up some BIP elements. They just don't exist. The statement that the Board of Education has a duty to ensure certain things happen under 1414 is a little misleading. The start of that section of the IDA says the state or the LEA must do these things. But the suggestion that Kanawha County Schools doesn't have the adequate staff and expertise to provide behavior supports is not supported by the record. The Board of Education has more board-certified behavior analysts, the gold standard in behavior modification, than any other school district in the state. The data collection issue is, again, a state obligation. They are the ones that have the oversight requirements. Kanawha County Schools has school psychologists, BCBAs, liaisons between every school and the central office. So it's a bit of a stretch to say that we don't have the expertise that we need to provide what these children need. We ask that you reverse the certification order and remand the case for consideration only of GT and KM separate individual cases. Thank you.
Thank you. Thank you both for your great arguments. And as I've said to others, and you've heard us say it, we normally would come down and shake your hands. You may consider us virtually shaking your hands right now. We will do so perhaps in person later. Let's take a brief recess for just a few minutes, and we'll come back and give.
This honorable court will take a brief recess.
All about the Washington.
The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit.
Let's be seated and proceed with the last case. Move directly with the appellate's argument.
May it please the court. I'm Glenn Fogel. I represent the petitioners in this case. Ms. Lazo Gavidia and her son. Seated to my right is David Lunell. He helped me on the brief. He's a senior attorney with our firm. This case presents a issue of first, I guess, impression with this court. Does Ms. Chavez apply in the situation of a motion to reopen an immigration court situation? And the government's argued and presented cases where it says that it doesn't, because it only Ms. Chavez only applies in a stop time situation. But that's not really the case. When you look at Ms. Chavez and you read it carefully, it's way more than that. What does Ms. Chavez say? One of the main points that Ms. Chavez says is that an NTA, or notice to appear, is like an indictment in a criminal proceeding. So it's a charging document. I practiced immigration law for over 30 years, and an NTA is the equivalent of an indictment in an immigration proceeding. So Ms. Chavez also states that in order for the NTA to be proper or to be complete, that it has to include everything. It has to include the time and place of the hearing. If it doesn't include the time and place of the hearing, it's not an NTA. It's incomplete. Just like an indictment or any other charging document was without an important element. Say it left out the element of one of the criminal statutes, or it left out another important part of the indictment, it wouldn't be complete. It would be dismissed.
So can I ask you?
Yes.
So the in absentia provision we're looking at doesn't refer to an NTA. It says after written notice required under paragraph 1 or 2. I understood your position. I'll tell you what I understood your position to be, and you tell me if it's wrong. It might be.
Okay.
It seems like your position is if you don't have a valid NTA at some point in the past, you can never have a valid paragraph 2 notice.
That's correct. That is our position. And I think that's the same thing that Ms. Chavez said in the context of
No, Ms. Chavez says a paragraph 2 notice can't fix a paragraph 1 notice. You can't add the date and all of a sudden put the two together and have an adequate paragraph 1. It doesn't say you have to have a paragraph 1 to ever have a paragraph 2. It just says paragraph 2 can't fix and complete paragraph 1 notice if paragraph 1 notice is required.
Well, I think that's the whole point here. You have to, in order to give proper notice, it has to be predicated upon the service of an NTA.
So if a non-citizen has an improper NTA for any reason, maybe it was missing something else, they get a paragraph 2 notice and they do go to the hearing and are removed, they have no argument that they shouldn't be removed, that should be thrown out because the NTA was invalid. Is that right? Because we have said,
well, I think that's, this court.
We've said there's jurisdiction for removal there.
Right, but again, that's a completely different situation because they've actually gone and availed themselves of the court. And by doing that,
if the same person had an invalid NTA, they get the paragraph 2 notice, same person, read it, understand where to go, what to do. But instead of choosing to go to the hearing, they choose not to go to the hearing. Then they can get the in absentia removal order thrown out because of the NTA was invalid.
Correct, Your Honor. I mean, that's exactly what you are. I mean, it's the same thing. Again, it's a different situation because they actually have gone to the court and have availed when they go to the court. I mean, they cure that. I mean, that's a different issue where they've cured and availed themselves of the court.
If they actually go to court, have they waived any argument for improper notice?
I believe so. I mean, that's where you get. I mean,
It's an odd type of law
Yeah.
we're dealing with here. We're dealing with a situation where the Supreme Court's made it clear you can't put these two things together. The section 2 dealing with a whole different matter of change. And the question is, how do you change something that wasn't done correctly in the first instance? Is probably where your argument's going, and it kind of conflates and goes back and forth. This is a case that it does present a very interesting issue to us, particularly the issue of where she doesn't even give a change of address. That's a very important issue here too in this case. But I'm thinking in any instance, if you show up to court, how do you go in and say you don't have improper notice? It seemed to me you waive it.
right. If you show up to court, I mean, for instance, you could show up to court and say and move to dismiss it because it didn't have, it didn't have the time and date, or there was something deficient in the NTA.
So you've waived notice. You've waived what if you show up?
Well, I think what you've waived the, I think the right, well, when you show up, you have a right to challenge the NTA, and you can challenge it if it's deficient. If it's deficient in the first place, you can't be charged with receiving notice. And when you look at the statute,
You've shown up because you received notice of the relevant hearing, right? Because you were able to show up, right? And so you've waived any argument that I didn't know about today's hearing because, well, you're here and clearly you did know about today's hearing. That's what you've waived, right?
Right. In
But
this
it's
case,
not, then why does it matter that someone who chooses to show up, I think this helps us see that what matters is notice of the paragraph 2 notice, right? Of the hearing where they're actually determined to be removable, not a previous hearing that never happened because it was rescheduled.
well, I think, and I think one of the other things that I think is important when you look at Ms. Chavez says is that the paragraph 2 notice, it only applies when there's a change in the hearing date. So when there was no hearing date, when there's no hearing date given in the first place, there's not a change.
Well, that's certainly, the court was using that to interpret paragraph 1, right? To interpret what does it mean to have an NTA. We know there has to be something in there that's changed, but again, I don't know that that means when you get notice under paragraph 2, that you don't know where to go or when to go if you've received a document that tells you where and when to go.
Well, okay, if you received it and you get if you received it and you go, again, I think you've waived that because you actually did receive it. The petition in this case, they didn't receive it because it was clearly
why didn't they receive it?
Because it was sent to the wrong address.
And why was it sent to the wrong address?
Well, it was sent to the wrong address because they didn't notify because she didn't know.
And has
She didn't understand to do that.
Any court held that the failure to update the address, that you can still get the in absentia removal order, you can get that rescinded even if you didn't give the government anywhere to let you know that you didn't update your address.
If you weren't provided with the proper notice, if you weren't provided with proper NTA in the first place. I think that's the whole issue here. And that was the issue. I think that's what Ms. Chavez clarified about Pereira. And my reading of Ms. Chavez is and Pereira is that if the NTA needs to be proper, if it's not proper, it's not a good NTA. Now, again, you can maybe waive it if you show up or something later on. Where I think this court has held. If these were people that already availed themselves, already had a hearing, already had their, had their day in court and were ordered removed, and then came back years later and tried to say, oh, well, the NTA wasn't proper, therefore the whole thing needs to be thrown out. That's not the case here. I mean, what's clear is there was a notice given. I mean, and that's the whole point, is that you can't serve somebody with a document saying you got to be in immigration court, not give them the day, and then order them removed.
But the Fifth and the 11th Circuit have said, well, if you don't give them your address as required by statute, the statute says you can be removed even if you didn't get the notice, because the obligation is on the non-citizen to update their address.
And there's, I'm going to tell you that I believe those cases are wrong. I think they're contrary to Ms. Chavez. Both those of arguing in the 11th Circuit many times, and I've won and I've lost, but they've been wrong before, and I think they're wrong here. I think their interpretation, and I don't see how you can read Ms. Chavez and not see that this applies to more. That this is clearly, Ms. Chavez says the notice to appear needs to be proper, it needs to be complete. In order to go to the second, the second paragraph or noticing, it relies upon the notice to appear being complete in the first place. If it's not complete in the first place, it's not proper, and you're not properly served with it. And even though you receive it, it's not a proper NTA, and that's why that's why we believe that that's why our interpretation of Ms. Chavez here. I can respond to the government. I mean, that's really we're not talking about complex issues here, and I think you get my point. But and I'll respond to whatever the government has to say.
All right, you got some rebuttal time.
Okay.
We'll hear from the government.
Good morning. May it please the court, Brendan Hogan for the government. In this case, with regards to Pereira and Ms. Chavez, there are two issues. The first of one, which is easily disposed of because this court has already discussed it in Citios and Cortez, and that's whether in any circumstance does an immigration court have the authority to issue a removal order even when the NTA or notice to appear omits the date and time. And this court has already said, yes, they do. They can initiate removal proceedings and issue a removal order in that circumstance. The more narrow issue in this case, which has already been addressed by the 11th Circuit in De Costa Gomez and the 5th Circuit in Gutiel, is does an immigration court have the authority to order a petitioner removed in absentia when the NTA does not have the requisite date and time information? And this court should follow those authorities because of the reasoning in those cases, which is under the A2 notice that your honor mentioned earlier, no notice is required if the petitioner fails to provide or to satisfy their address obligation as required under 1229 A1F. Before the immigration court and on direct appeal, the petitioner conceded she never changed her address. In his opening statement, counsel conceded she never changed her address. Therefore, because she never changed her address, no notice is required. Counsel hasn't pointed.
Can I ask you about that? A lot has happened since the board's ruling in this case. And most importantly, it seems that matter of La Para was issued by the board, right? So that's the board's precedential decision interpreting these statutes and these requirements. And they say what you just said, that no notice is required if you don't update your address. In this case, before that decision came out, here in this decision, the board didn't go that far. It didn't say anything contrary to that, but it seemed to suggest here that, whatever notice that was given was sufficient, right? Notice was sent to the house to the last address, and that was sufficient. I guess there's two questions here. Do we need to remand? Would any purpose be served by remanding for the board to consider La Para? And part two, is there any sort of deference that you're arguing for? I didn't see any deference argument. You're just saying if the statutory language is clear.
Well, two things, Your Honor. One, there's no reason to remand because, for one, the board didn't reach Ms. Chavez or Pereira in its decision because in the direct appeal, there was really no development of any argument regarding Ms. Chavez Prayer at page 17 of the record in the direct appeal. Prior counsel did state Ms. Chavez changed the stop time rule, but he didn't go the next step of arguing that somehow that the immigration court lacked authority. So there's an exhaustion problem right there. But also, as you pointed out or implied, remand would be futile in this case just because by not complying with the statutory obligation, no notice is required. Matter of La Parra and the 11th and 5th Circuit decisions are fairly clear about the reasoning for that, and the statute's also fairly clear. Counsel points to no authority that an absentia order can never be issued. He doesn't point to anything that would relieve his client of her statutory obligation under 1229A1F to provide an address, and she's never done so.
Except the Supreme Court talked to us about what the government's obligation is in Nia Chavez, right?
But with respect, Your Honor, that case was not looking at the statutory obligation to provide an address in the first place, though.
No.
And so they didn't go that far. And so therefore, again, under the narrow circumstances of this case, remand would be futile.
You gave two reasons, and I didn't understand your first one. Can you say that, or maybe I just didn't hear it? I seem to be having difficulties today.
I apologize. I'd speak too fast, Your Honor. The first issue, the broader issue, is whether the immigration court ever has the authority to order someone removed simply because the NTA omits the date and time, not just in absentia orders, but even to just initiate removal proceedings in the first place. That was already addressed in Cedillos and Cortez.
Okay.
All this, she didn't give the address, and therefore she's not entitled to notice. What would happen had she given the address in a case like this?
With respect, Your Honor, that would better be served in a case where that issue actually comes up, because as you pointed out earlier to counsel in his opening statement, this is a very complex area of the law, and depending on
like dealing with the situation where she didn't and what happens for not doing it. In other words, she didn't do something, and therefore there's a penalty that comes for not doing it, which would seem to think if you did it, then you don't, there's something that happens that would be good. And it seems to me, if you don't give a change of address, and then the section 2 type notice is given of a change of a hearing, based of a hearing that would not be able to be sustained because of the first deficient notice, the first one. So the whole question is, how do you do a change to something you're not entitled to, or you didn't do correctly in the first instance? How do you change something you didn't give proper notice for in the first instance? That's the question. I mean, we can harsh this thing out and look at just the law here and say, well, you don't get notice because, at the end of the day, you didn't give a change of address, and it says right here you don't do it. But when you look at the statute, it just doesn't seem to make too much sense to me. Well, if you gave the notice, then you can come in and argue this second notice is deficient because it can't follow a two-step process. So you lose something that I don't get it. But here's another question. I mean, and maybe we just can't really partial that. But here, what does it take to fix these problems below? You enter an absentia order. What would it? I mean, how much delay would it have been to say, okay, here's proper notice, and we're going to have this hearing?
Well, I believe going forward, and I don't have the statistics in front of me right now, but I can get them for Your Honor after argument if he wants them. But my understanding that each component within Homeland Security, the Border Patrol, USCIS, and Immigrations and Customs Enforcement now have, in most circumstances, access to the court's docket, where they're at least trying. So going forward, this problem should be seen less and less by the courts, I guess is what I'm saying.
It just seems we're up here. I really don't like dealing with procedural problems when we're dealing with human rights and we're dealing with, why not just give this lady a hearing? We courts can make up all the rules we want in terms of how to do this. We got the statute here and we're going to follow it strictly here. The court came up the Supreme Court came up that case. It was surprising me the way they wrote that Ms. Chavez case that said you don't have that date and time in there, it is defective and you cannot stack it with the second one. I would have thought you could, to be honest with you. When I saw it, I was shocked to see they said that, but they said it. And I think the idea is, you got people out there who are dealing with something that's a little bit more than us looking at these papers. This is real stuff to this lady and her son. And she is, for whatever reason, she moved. So she moved to try to put the son with the husband. I don't know the circumstances, but the human problems of what courts deal with. And when we spend hours and hours, as we're doing, to delve into the procedural morass of did you punch this button and do that, it just doesn't seem to fit the purpose of anything that we're dealing with here. And that's why I asked the question, if even below, because it would be nice, you wouldn't even bring this stuff to us. You would go and just say, even the government, you says, well, it's a defective notice, whether it is or not, it's easy to fix it. Here's one right here. And Your Honor, if everybody can agree, we can have a hearing. He's already had the hearing. He's probably going to come back in and just say, well, I'm going to go back through it very quickly. Everything is here, boom, done. Then we don't have that issue. We deal with the merits.
That's a fair point, Your Honor. But again, even before Ms. Chavez and Pereira, this court was dealing with cases, in absentia cases, where people failed to provide their address and they were being ordered removed in absentia, even though, as you said, there is a human being involved with a claim for relief. But they forfeited the right to present that claim to the immigration court by not providing their address. And again, unfortunately, in this case, at every stage in the motion to reopen before the immigration court,
Has there been any circuit go the other way? Did the Ninth Circuit go a different way on this?
Well, in Singh, they just recently issued their en banc decision, but there's a slight nuance to that case in that it doesn't involve the obligation to provide an address. It's more of the question Your Honor was asking about earlier, which is there's no issue about the address, but whether you can cure the NTA by giving the A2 hearing notice. So it's slightly different. Whereas the Costa Gomez and Gutiel, the 11th, 5th Circuit cases, those discuss the issue that's squarely present in this case, which is the failure to provide the address. 1229.
You had a hearing from the beginning. You had an initial hearing. You really said not one word to her. You didn't even give her any notice at all. Then you do a change of hearing notice and send it to her. She does not give you her change of address. Does that mean now it's waived? She doesn't get any notice, even though she never got a notice at all in the initial one. Is that okay?
Yes, Your Honor, because under A2, no notice. Once it shifts to that the hearing notice after the notice to appear.
Let me make sure I'm saying what I say, because I'll make sure we agree with what I'm saying. I said, look at the first hearing. No notice whatsoever was given of the hearing that's coming up. The court did it on the docket. They did, everything is there, but she got absolutely nothing. Didn't get date, time, didn't get anything. And then subsequently, she moves. And then you send a change of hearing to her for something you never gave a notice at all. And you're saying that's okay because she did not give a change.
That's correct, Your Honor. When she was served with a notice to appear in this case, it was read to her in Spanish. She signed it, confirming that she had received it. And the notice to appear has very clear instructions about the obligation to provide the address, but also the consequences of failing to provide the address. In an abundance of caution in this case, when the DHS released the petitioner under an order of supervision, that document also warns her you have to inform the immigration court and DHS if you move.
Is there any opportunity for her to tell you why she didn't do this? Or any due process in terms of, it could be any number of reasons why you, I don't know, maybe it says you got to give a change of address, but I'm just wondering, that presupposes there's no possible defense if it's just that hard line. You just didn't do it, boom. But is there any opportunity for her to come in and say?
She had an opportunity in both the motion to reopen and the administrative appeal, and no explanation was ever given. The court doesn't have to get to that issue.
So the court never made a determination that she has to.
She all but admitted that she didn't do it, unfortunately.
Let me ask this. If the government instead of issuing a paragraph 2 notice, say the government realized after Ms. Chavez, we blew it, hit this paragraph 1 notice was not a sufficient notice to appear that we gave her, back when she first entered the country. We got to fix these. We want to send her an adequate notice to appear, paragraph 1 notice. And, we want to send this to her so that we've got it right and we could have these hearings. Where would they send that?
They would not be able to serve the petitioner with that because she didn't provide an accurate address. As she admitted, they would have no way to give the new document to her, the new charging document.
What happens if the government, same type of scenario, I like these little hypotheticals. What happens, okay, we got the instance where you've given this defective notice, you know it as the government, and then you find out she's moved. He says, why don't we do a change of hearing date and send a notice to her, knowing she's moved and she's not giving you the change? Same thing?
I'm sorry, could you repeat?
In other words, you know she hasn't moved. And you also know you have a defective notice as the first hearing. So you decide, why don't we just do a change of hearing and send that to the old address, knowing she's moved or having reason to believe she's moved. And if she doesn't respond, then boom, she's out.
I mean, perhaps they would do that now in light of the evolving case law, Your Honor, but nothing would, if they have information that the petitioner has not fulfilled her statutory obligation to provide a correct address, they wouldn't have to send a hearing notice. They would be authorized to order her removed in absentia in that scenario.
I think we beat this horse enough. Judge Rush, got more questions here. We'll go and hear from the other side.
Thank you.
Thank you.
I'd like to start out with this is a quote from the last paragraph of Ms. Chavez. When the government seeks a procedural advantage against an individual, it will at least supply him or her with a single reasonably comprehensive statement of the nature of the proceedings against him. What does that say? What is Judge Gorsuch saying there? I think he's saying that you have to have a complete NTA, period. And
it was important there because it stopped the time. It did something significant and someone needed notice of that in a document, and the statute referred to a notice to appear, right? But that's all very different here.
I really don't.
What matters here, right, is notice of the hearing that you're going to be removed at.
Yeah, but the notice to appear says that you need to be somewhere at a certain place and time. And if you don't know what that is, it's the same thing. I mean, I think that's what Ms. Chavez is saying here, is that this is a defective indictment, charging document, whatever you want to call it. If the charging document is
what do you do about the fact that the statute says or two? It doesn't just say paragraph 1, it says paragraph 1 or 2.
Because paragraph two is dependent upon paragraph 1. It's dependent upon giving the time and date of a hearing.
But that's not the hearing where that hearing never happened. Paragraph 1 hearing never happened.
Right. It never happened because it wasn't there. I mean, it wasn't on the notice to appear. It has to be on the notice to appear.
But even if it had, so there had been a date on there, but there was a
Right.
change issued. There were multiple changes issued in this case. It changed to Charlotte location, and then it changed the date and time.
No, there was never an original. I don't think there was an original date and time.
Sorry, a paragraph 2 note. There were multiple paragraph 2 notices. One changed it to Charlotte, one changed it to, or gave the date and the time, right, in Charlotte.
Well, what actually happened here, the notice to appear had, I think, Pearsall or somewhere in Texas where the home where they were originally detained. That was where the court was originally. They moved to North Carolina and gave it an address of somewhere in the first address. Then they were served with the NTA, but the NTA had not been served on the court, hadn't been filed with the court. So proceedings actually hadn't been initiated until they're filed with the court. They weren't filed with the court until later in July. She actually went to immigration in Charlotte, reported, and she was still living at that first address. Then she had, then she moved after that and didn't let them know. But she had never been served with the NTA hadn't even been filed with the court, number one. And number two, she still was never given a proper date and time. So the NTA in the bottom line, which is the important document here, the document that gives the initial date, all they had to do, and all the government has to do here, is to put a date and time on there. And I think, we don't have this issue if the person is personally served. But when they don't, and I think that's the whole problem, and there's thousands and thousands of these cases out there where the people weren't properly served and they get in abstention orders because it gets sent to the wrong address. But again, we talked about this enough, but I believe that Ms. Chavez is very, very clear in that this notice, the second noticing, paragraph 2 noticing requirement is predicate upon a proper paragraph 1, which is the NTA. If the NTA noticing, the NTA, which is the first paragraph 1 noticing requirement, is deficient, then you can't have a paragraph 2. And all right, thank you, Your Honor.
Thank you both for your arguments. This has been a pleasant opportunity to share with you. We would normally, as I say, come down and shake your hands, but we're doing so virtually today. And all of you have very safe trips home. We will now adjourn the court.
This honorable court stands adjourned. Sign a die. God save the United States and this honorable court.